ESG disclosure requirements are definitely a moving target as new rules are being introduced. In March 2021, the SEC announced an ESG disclosure task force and simultaneously announced that it would propose new rules around ESG disclosures. The goal being to create a framework whereby investors could compare ESG disclosures across companies. They wanted to standardize how ESG disclosures came out. Then, in March 2022, the SEC announced new rules around climate-related disclosures. These new rules would require public companies to disclose climate-related risk, including risks related to greenhouse gas emissions. The SEC has not yet waded into board diversity disclosure requirements, but other entities have. In 2021, NASDAQ announced new rules around board diversity requirements, and several states are considering similar rules around board diversity requirements. All of these new rules come in the context of investors who have also demanded new rules around ESG disclosures. Investors want to know what companies are doing around ESG, they want to understand it, and they're demanding more fulsome and robust disclosures from companies. All of this is in the context of Rule 10b-5, which remains the standard for company disclosures. Rule 10b-5 requires company disclosures to be accurate and not misleading, and not to omit material information. With new disclosures comes increased litigation risk. We've started to see an increase in investor lawsuits, class actions, and derivative suits around ESG disclosures concentrated in two main areas. First, board diversity disclosures and climate and environmental disclosures. On the diversity disclosure front, in the summer of 2021, there were 12 derivative suits filed, all alleging that the directors, one, breached their fiduciary duties by not having enough African Americans on the board, and two, violated the federal securities laws by misrepresenting their commitment to diversity. None of these suits survived a motion to dismiss. For the most part, the court found that these statements about a commitment to diversity were aspirational in nature and therefore were not subject to liability under the federal securities laws. Because these suits were ultimately dismissed, they presented very little financial risk to the companies, but they did act as a form of public shaming. These suits essentially accused these directors of being racist, of purposely excluding African Americans from their board. This also put the companies in the difficult position of having to argue that statements about a commitment to diversity were aspirational rather than sincerely held beliefs.